for you and Ms. Wong. We couldn't do this without you. No problem at all. And particularly focus on the answers that you provided to the questions we asked on the last occasion, and maybe one or two other items. Does any member of the committee want to go first? No? We seem to have lost Minister Khan. Okay. All right, gentlemen. Well, I had some questions on the responses you gave us with respect to Atlantic LNG. If you go to the document, it is page 5 of the document. All right, now you're familiar with what I'm talking about. This is your responses to us, Mr. Lashley. Yeah. The second to last paragraph, where the last sentence, where you say most contracts provide 50% sharing of the diversion upside with the gas supplier. However, in one contract, there is no sharing of the upside. Could you explain what that means? What you mean by that?
Good morning, Chair and members of the committee. First, let me just put in context the response that we sent in, and I think we alluded to it on the last day. A lot of the contractual arrangements are just that, subject to contract and confidentiality. So the response or responses may seem to be broad. So we've kept some names out, certainly in terms of details and contractual details.
On that, perhaps you can answer a question that I had asked in another forum. These confidentiality agreements are between who and who?
It would vary in terms of the parties to the contracts. Some contracts we are party to the contracts, and we actually are bound by the confidentiality provisions of the contracts. Other contracts, we may have sight of the contracts, but under side letters of confidentiality as well. I can let our legal representative probably speak in more detail to that.
Okay.
Yes, good morning, Chair and members. Yes, as PS was indicating, there are certain agreements that were entered into in respect of LNG between the government and some of the companies, and those are mainly contained in project agreements between us and the Train 1 partners, the Train 2-3 partners, the Train 4 partners, and those do have confidentiality clauses. In terms of the LNG sales agreements, those are entered to between the companies that are producing under the PSCs and their ultimate buyers, and those contracts, as PSC would have indicated, we would have sight of, but we are not parties to. And so they do contain confidentiality provisions, but those are as between the seller and the buyer of the LNG.
In this document here, again, I believe it is on page 9. I think it's 9. If you look at the first paragraph on page 9, the top there, go to the sentence that starts with, in addition, 86% of its company's Train 4 cargoes over the same period have been sent to Spain and receive extremely low prices that are not a reflection of European benchmark prices. And then, yes, page 8, Mr. Lee, you're quite right. On the second paragraph, last sentence on page 8, in recent years, some companies have opted to manipulate the spirit of the contracts, so the original intent of these contracts are not being honored. How do we as a committee find out what are these agreements that are not being honored in the spirit? How do we find out what's going on, since everything seems to be locked up by confidentiality?
In another edition of these discussions, I heard some sort of indication as to probably another mechanism for having some sort of interaction, maybe in camera, where speaking a little, more freely, we can do it. But I mean, that's notwithstanding the fact that there are certain details which we are still bound to not disclose based on disclosures that have been made to us. So I'm just suggesting maybe that might be a mechanism that the committee can explore.
I'm not an attorney, so I'm just asking, if, when you say it's been disclosed to the ministry, but the ministry can't disclose it to anyone else, not even to the government, is that what? That's what I'm trying to get clear. So who can't? I'm not an attorney, so you have to guide me. If it's been disclosed, information is disclosed to the ministry, and for instance, this committee has an in-camera, completely private session, is it still that there's still information that even in a private session, you will not be able to disclose? Is that what you're saying?
I will allow the attorney to guide you, but generally, the sort of standard that the recipient of confidential information is held to most times is that they have to ensure that any disclosure that they make, first of all, is done with the permission of the disclosing party, and two, that in fact we receive undertakings from any other party similar to what we are bound by. So those are the types of things normally that would apply to disclosures covered by confidentiality.
Chair, if I may. I am an attorney, and I just want to find out exactly why it is that the Parliament or the government of Trinidad and Tobago, whom we represent, and I imagine would be the signatory to these contracts, are not allowed to know what the contents of it. I agree we could do it in camera, but it seems very strange to me that these are contracts that deal with the natural resources of our country, and we are the representatives of that, that we should be held in the dark and not know what is going on. How are we going to make a report or suggestions about improving it if we don't know what the deal is? That to me just seems alien and unacceptable.
Okay, perhaps it may be helpful if I could respond in broad terms, because as PS indicated, we can't indicate specific companies or specific contracts, to try and assist with the area you identified earlier, Mr. Imbut. When we spoke about, you said there was one contract that didn't have the destination premium. In some of those contracts, what we did is, under the base contract, there's a particular destination that those cargoes were agreed upon between buyer and seller. The contract allows some flexibility in terms of excess cargoes, and even in the contracted cargoes. And it's what we refer to as a destination premium. And I'll let my friend on the other side, Mr. Jeremy, assist when I'm through. So if that cargo of LNG was destined, let's say, to the US, but the buyer has been able to find a better market, a better price for that LNG. Our cargoes have gone as far as Korea and Japan and so on. The price that they would get for the cargo going to the premium destination, obviously, is a better price. So you deduct the base price from that price, and that destination premium, which we refer to in the contracts, is divided between the seller and the government, 50-50. The contract that did not contain that clause, it would have been a factor of it was just not negotiated by the government at the time, so that it was omitted from that particular contract, and we did seek to improve on that in the later contracts.
For a destination or for one of the trains? What is that? That's what I'm getting at. What do you mean by a contract didn't have an upside premium? What do you mean by that?
Okay, for those of the committee that are not familiar, I'm going to give you a little background. All of the contracts, the gas we're talking about, natural gas, comes from the upstream under production sharing contracts, all right? And the parties under those contracts. Those, the LNG, so when the contractor companies discover the gas, they then find a market for that gas. It goes to, if it's LNG, it goes to Atlantic to be liquefied, and then it is sold to whoever the buyers, they negotiate. It's not the government that finds the buyers, it's the sellers. So that it is these upstream companies that would be selling the gas that would have negotiated the sale of the gas under those PSCs to whoever the eventual buyer is in the market.
I'm driving at is what your words here on page 9, where you say that there was a particular contract. Is it page 9? Is it page 4? You sure? Page 5, yeah, page 5, where you say in one contract there's no sharing of the upside. That's a contract for what?
Sorry. This would be one, it would be the project agreement between the government and these companies, and it would also be in the LNG sale and purchase agreement between the companies, again, the same companies in the upstream that are selling the gas to the buyer.
Yes, but again, I don't think you're understanding what my question. So I'll try to be a better communicator. Is this a contract for all of the LNG coming out of a particular train? Or is it a contract for some of the gas? What is it? Okay, that's what I'm driving at.
Chair, perhaps I can allow Mr. Jeremy just to walk you through, because the question you posed, I think it brought it out. The commercial arrangements are between a number of entities on the upstream. There are several trains, and there are different arrangements for the trains, and then there are several parties or entities that are responsible for marketing on the downstream end. So I'll ask Mr. Jeremy to just walk you through.
As the peers had mentioned, in terms of the contracts, they have particular arrangements. So just one correction in terms of the PSC, they are both ENP and PSC in terms of where the gas is sourced. Now, let's say, for instance, in Train 1, there are 2 buyers of the LNG to particular markets. In Trains 2 and 3, there are about 5 different buyers of the LNG. One, in terms of Trains 2 and 3, there's one particular buyer in his contract does not have where you can share 50-50 the arrangement.
Percentage of the output would that be?
Let's see. It's about between 30 and 40%. It's about 30 and 40%.
How much?
30 and 40%.
30 to 40% of Trains 2 and 3.
Yeah.
Yeah. All right. That's interesting. So, I just want to ask a general question now. So we as a country have caused this project to happen, Atlantic LNG, but we can't find out what's going on as a country. That's my question. We as a country have facilitated the creation of the Atlantic LNG project and the production of gas, the selling of gas, the processing of gas, the sale of LNG. We facilitated all of that. But we as a committee now trying to find out, are we getting the best deal? Are we getting the best value? Are we getting the best price? Are we getting the most amount of tax we could get? We can't find out. That's my question.
The thing about it, I don't know whether it's a question or an assertion. It's a question, because I was suggesting that one of the ways to get some more specific information is perhaps have a closed session.
I understand that.
Yes.
I'm trying to get there.
Yeah.
That there is a way that this committee can get more information.
I mean,
But you're implying that if we speak to you out of the public eye, we can't talk about it. That's what you're saying.
yes, there are constraints that the Ministry of Energy would be.
All right, I'll hand you over to the other members of the committee now.
I just,
Go ahead.
no, let me just, I mean,
Whoever want to go
I
ahead,
just
go
want to make a general point here, please. We are committee of the parliament. The parliament is the highest court in the land. And fundamentally, unless it is very extraneous circumstances, should the parliament not have access to certain information? I just say that as a general principle. On page 8, second paragraph, I want to repeat what the chairman said. However, in recent years, some companies have opted to manipulate the spirit of the contracts, and so the original intent of these contracts are not being honored. I want to move on to page 9 to repeat again what the chairman has said. Last paragraph, last sentence in the last paragraph, on the first paragraph. In addition, 86% of this company's train 4 cargo over the same period have been sent to Spain and received extremely low prices. That is not a reflection of European benchmark prices such as NBP. And it concludes by saying, the net result of this effective swapping of cargoes is that a significant amount of value is captured by the marketer outside of our tax net, and the government of the Republic of Trinidad and Tobago loses out on this revenue. Well, that is a very, very fundamental statement. And we have a responsibility to the population, because here we have an industry that is the prime revenue earner for the state, and it is clouded in secrecy. So while we don't want to breach any confidentiality agreement, as a committee we must find an opening where certain amount of information has to be shared with this parliamentary committee to bring greater clarity to this issue.
Thank you, Mr. Chair. I want to join in supporting the comments that have been made to date on this issue. I believe that the ministry has the ability to write to these agencies and say the parliament, the committee of the parliament, which is to have full access to the information, and with regards to the confidence, and allow the companies to say no, because that would send a particular type of message. Because in a closed hearing, the committee would like to have full access to all of the commercial arrangements. And of course, the parliament is known for its confidentiality. Issues of confidentiality should not arise regarding the parliament. I believe this is because we can't function in a space where we have an industry, Mr. Chairman, that is using over 70% of our gas on a daily basis. By my calculation, Mr. Chairman, based on the submission of the ministry in the previous submission, I have done a calculation where I've netted off, I've done a net backed off shipping based on the submission of the ministry of the volume sold and the various markets we went to, then the average prices. The LNG business is generating in the order of $60 to $65 billion in gross revenues a year. $65 billion in gross revenue, and that is net of shipping. That's net back. So that we have to figure out some way to understand, are we really getting from, you would be a well-aware minister of what your take is. That doesn't need to be public information. But when our industry is generating more than the national budget, then we have to have very clear sight of what is going on with that industry. And we have to create new means, create creative avenues to try to see how we could understand what's going on and try to make sure that in a state where we have a wasting resource, that we try to make sure that we capture as much rent as we can and make sure we have the structures in place to do so. I just have a question after my statement, Mr. Chairman. I know the same issues on page 9 of a document about the swapping of cargoes. What does the ministry use to track? Because for you to be able to say this, I assume that you're tracking the cargoes. I have access to a nice online portal where when a cargo leaves here, I know the ship number, I know where it goes. So they go to Boston and they change. I can tell you what happens to the cargo. There's services available. So that when the ministry is making this statement, I suppose that the ministry should be able to provide some guide as to how much value has been lost, as to when the cargo is actually sold in the market. Because there's services that are available from Lloyd's and from other parties where you can actually track every day where the ship goes. And it's a subscription service, it's not free. So I suspect the ministry is using that, but I want to understand how is it, because for the ministry to make this statement, the net result is that significant amount of value. I want to understand, what do you mean by significant amount of value? How are you estimating that, and what is it that you're using?
allow Mr. Jeremy to respond specifically to what you're saying, but let me just point out that the monitoring or the tracking of physical delivery of cargoes is what you are speaking to, and that's what we monitor as well. But there's another element in terms of paper transactions that can take place that are outside of our jurisdiction as well.
Just come in here. You've made some statements here that companies have opted to manipulate the spirit of the contracts. So the original intent of these contracts not being honored. What are you doing about that?
You want me to answer that first before Mr. Jeremy?
Doesn't matter.
Yeah. Just, well, in terms of this particular instance, we've had some extensive negotiations with the company. They have not borne fruit to date, because certainly we've indicated and we've pointed out the issues we have with them. Of course, their response has been, well, they are not dishonoring the contractual provisions. There is contractual freedom available to them to do certain things. But our position has always been, as originally conceived and drafted, the contracts were designed to facilitate a particular set of marketing arrangements. In fact, as Ms. Poywink has indicated, in some other instances when we provided for additional flexibility, the contract was adjusted to ensure that there was upside sharing, because we realized that in the changing environment for LNG, it behooves all stakeholders to seek the best price and the best opportunity for cargoes. But certainly, in all fairness, if in fact a cargo coming from Trinidad and Tobago receives a particular price with a premium, that premium, along to our mind, should be shared.
All right, but let me tell you what I mean by the question. When I ask what are you doing about it, have you received legal advice on this?
You want to?
Internally, yes. External advice outside of the Ministry of Energy, no.
Not yet.
Not yet.
Okay. And then with respect to the comment about 86% of Train 4 cargoes being sent to Spain and receiving extremely low prices, are they allowed to do that contractually? Go ahead, Mr. Jeremy.
Yes, they are allowed to divert to destinations of their choice. It is in the contract in terms of to get better pricing. But what we are referred in the statement is that the companies, in terms of pricing in the market, that's what we are referring to, in terms of diverting to markets and fetching prices, which in our view are not the best price that should be had in the market.
Why would a company sell its product at a lower price than it could get elsewhere? Why would it do that?
To also answer Mr. Small's question, the contract are between the LNG buyer in Trinidad, buys from Atlantic, and the marketer, right?
Are they selling it
and
to
it is
themselves?
not, the contract
Are they
is
selling
not
it to themselves?
correct in terms of, and
So that's
but-
transfer pricing then?
no, but it's based on contracts
No,
which
it's
were
okay.
approved by the
I
government.
understand. So they're selling it to affiliated or associated
Correct,
companies,
correct.
which they have an interest in.
Yes.
So even though they sell it at a low price, they then benefit from receiving that cargo, which they could then sell again. So they sell it, it could be sold 2 and 3 times, the same cargo. It's a hypothetical question I'm putting to
Well,
you.
no,
Another way, Chair, the control and management of the portfolio of cargoes is outside of the jurisdiction.
I understand that. That's not my question. I asked first, why would a company sell its product at a lower price that they could get in the market? And then we got to the point where it is agreed that they could be selling it to an associated company, therefore selling it to themselves. Is it that when they sell it to themselves, they then sell it again to somebody else? Hypothetically.
Well, what we get is really what is reported.
I know
And that's
I'm
what we
asking
based
you.
on our reporting.
Yeah, I know
But,
that.
you know, it's hard for us to see because we don't track it. We don't track the cargoes out.
Well, I think we need to start tracking. Okay.
And then we need to track any cargoes.
Morning to the panel. And just leading off with the discussion we just had, and I want to just carry that into question 9, which is the rationale for the markets for LNG exports from 2005 to 2015. And on page 12, I want to direct and maybe get some clarification in the second to last and the last paragraph of the export to North America. And does that also play out in this scenario that we have been discussing a while ago? Because you talked about the LNG to North America had been down between 2013 2014, and it increased in 2015. And then you talked about you mentioned in the last paragraph, it must be noted that the region, and the region I guess is assumed is Northeast region, is that correct? Is now set to become an LNG exporter. Are you saying that they're now going to be exporting our gas that we send to that market?
No. It is because of the shale gas in the U.S. They now have gas that they can now export. So the regasification terminals, which previously received LNG from Trinidad, are now being converted into liquefaction plants to the U.S. can now export.
Just this, I'm having an issue with this contracts. I'm sorry to go on about it, but you say that, however, in recent years, some companies have opted to manipulate the spirit of the contracts, and so the original intent of these contracts are not being honored. Now, if they're not being honored, and the companies are allowed to manipulate them, and the original intent is not being met, that means that those contracts are either faulty, or they're being allowed to get away with it, and they need to be redrafted or reconsidered. I mean, that is something that is of major concern. We need to know what is going on here. How is it that these companies are allowed to manipulate the spirit of the contracts and the original intent? That means the contracts have failed.
I will attempt to begin, and I will defer to my partner, Mr. Jeremy, to complete. In brief, Mr. Solomon, you are correct. At the time some of these contracts were negotiated, Trinidad and Tobago was obviously not experienced in LNG as we are today. So there are deficiencies in some of these contracts. As PS indicated, we have attempted to negotiate with the companies to improve the benefits and revenues to the country. And what we have been met with on the other side is, but they are honoring the letter of the contract, as we're saying, though not the spirit of it. And so that is a challenge that we have at the moment.
Let me come in here. Is there a dispute resolution clause in these contracts?
Yes.
Is it
but
arbitration? Is it litigation? What is it?
it is arbitration in the energy sector under the Petroleum Act.
So if Trinidad and Tobago felt that these companies were in breach, what would we do? We would file a claim with some arbitral panel. What would we do? No, well, we get in there. So if we felt that they were in breach, what would we do?
Well, initially we would need to seek external advice, so we would have to get.
You got advice.
We got the advice.
That it's not just the spirit of the contracts they're breaching. They are breaching
the letter
Actual obligations. Their
then we would have to institute arbitral proceedings. Yes.
Yeah.
Just to add, though, before Richard may also jump in, as I indicated, we've had discussions with the companies. The preferred route, of course, is first have a discussion to see if we can solve it across the table. But certainly, we've put them on notice that, in fact, if we don't get the sort of relief, that, in fact, any sort of pathway that's open to us, we will proceed, inclusive of litigation or policies that we may wish to
There
bring to
might be
bear.
an unfair question because I asked this of the Securities and Exchange Commission, and the answer was no. Have you ever taken any of these companies to arbitration?
Ministry of Energy, I'm not aware, Louis. You want?
The answer is no. All right, there's a first time for everything.
Can I bring some further clarity to the... the PS is correct in terms of what we are doing is when we see things that are not correct, we bring it to the local company. But the contracts are now with the government. We cannot bring the marketer to litigation or to arbitration. We have to get himself, the local companies to take action against, the affiliate. And that is what we find ourselves.
I understand. What I'm driving at is that, have you ever got to the point, I mean, I know the answer already because you've told me, where the government is of the view that, look, we are being cheated, and you go through the process, and you ask the local companies to deal with it, and they don't, and then you go to the point of, all right, you don't want to deal with it, then we'll enforce our rights under the contract. You take it to dispute resolution, you get a ruling. So you haven't done that yet. You've just tried to sort it out in amicable discussions and mediation and that sort
But
of thing.
there was in one instance where the government was able to get a particular company to take the marketer to arbitration, and they lost. And it was
I think I know which company.
Yeah, right, sir.
I think so, but that doesn't mean anything. I mean, arbitration, like litigation, is a lottery. You win, you lose. That doesn't mean you shouldn't try. Otherwise, we'd have no need for people like Mr. Solomon.
Chair, question? Question to the panel. Change the topic a little bit. Question 1, commencement date for stakeholders' consultations on the energy industry. Again, the response does not give us any comfort.
Yeah, Mr. Lashley, let me come in here. You gave us a non-response here, You say you'll do it when you'll do it.
What I was trying to indicate, Chair, was that it's not totally in the hands of us here. So there's a process. The process is in train, but we are awaiting confirmation.
But what you're telling us is that you have sent it to the minister for her consideration. So you throw the minister under the bus.
No. I think it's in a broader context than that. At the end of the day, I think what we're seeking is the most effective way to conduct the consultations. And in fact, we are drawing on the advice that we're receiving in terms of how we structure it. So.
All right, but I mean, we can't command you to do anything. We're just a parliamentary committee. We can only ask.
We are anxious to have them.
I wish I could command you to have this consultation tomorrow, but you have to be more specific.
Sure, and to the extent that we can be, we will.
What I mean is, what are your time frames?
Yeah, this month, the structure has changed, as I indicated at the last time we said. There was an initial construct of having about 2 or 3 large assembly of stakeholders. The thinking now is moving towards having smaller groupings clustered around their sort of common interests. So, for instance, upstreamers, downstreamers, etc., and having groupings that would feel free in the particular forum to have a productive and fruitful exchange with respect to policy going forward.
Mr. Lashley, I understand all of that, But you still have to tell us when.
That's the only specific that I can't give you today.
Because the minister is considering it.
Well, no, and it's even broader than the minister. With respect to in the national agenda, there are consultations on energy that we want to have as we move forward to framing the policy. So
All right, I'll
certainly-
tell you why I think it's important. A proposal was made to me as Minister of Finance that we should, as a government, seriously consider looking at the supplemental petroleum tax. Because the view of the industry is, well, the small players in the industry, not so much the big ones, was that this is outdated, that it was designed at a time when the price of oil was about $25 a barrel. So therefore, if the price shot up to 50, it would really be a windfall, you know. In other words, the price would double, so it would be an unexpected increase in price, and therefore you would want the country to benefit from that windfall that the oil companies would earn. But with the average price, Mr. Small did a calculation the other day. I don't know how accurate his calculations are, but he said the average price is $43. Am I correct, Mr. Small? But you calculated the average price of WTI over the last 20 years or something? The weighted average, yes.
The weighted average of WTI.
Right. So he did a calculation. So we'll assume that his calculation is correct. So if the average price is 43, $50 is not really a benchmark for a windfall. Now, how does one deal with this? Because right now, because oil is not 50, I'm getting no supplemental tax at all. And we used to get about $4 billion in SPT when things were going good, you know, 2013 and so on. We got about $4 billion in SPT for that year. Now we're getting zero. What the small companies are saying is, look, this is a penalty because at $49.50, my profitability is reasonable. But from the time it hits $50.50, you're imposing this additional penalty on me, this SPT, even though it's for the extra dollar. And as we go up to $52, $53, it's making my business unprofitable, so that I would prefer not to produce oil at $52 or $53 because I have the extra burden of the SPT on me. So they've asked for it to be increased. And they asked for it to go up to $80, which I thought was ridiculous. But the point is that it's a problem. We need to deal with it. Now, some of the advisors that advised me recently on oil and gas taxation told me we should look at SPT in the context of profitability rather than price. So look at how profits increase with an increase in price rather than benchmark the price and put a tax on that. The reason why I'm giving you this long story is we need to settle this matter. It can't be that, you know, because 8 months of this government's life has passed, you know, Mr. Lashley. I don't know, I counted, I don't know if you counted. We really need to get these consultations going. So could you impress upon your minister, since you're saying it's being considered by it, even though she's my colleague, could you impress upon her that we need to get the show on the road?
And we will, and we are just as anxious, Minister, to have the consultations, get the feedback. I mean, the input from the stakeholders is critically important in terms of framing a policy going forward that, you know, that works for, as you indicated, with the SPT issue, that works and is, you know, for not just the government but stakeholders and investors going forward. And it goes back to, as we mentioned on the previous day, the whole perception of the competitiveness and fairness, if you will, of our fiscal system, which we are in full agreement needs to be reviewed. The only point I would think is that we cannot finally settle it because this is a progressive, it's an ongoing thing. So you have to continually review and ensure that the measures you put in place are relevant for the current environment.
Let me tell you what I'm driving at with the SPT. It's either we increase the benchmark, or we link it to profitability, or we leave it at $50. We have to do something because it's an issue. And then there's also an issue with respect to marginal fields. and fields that are costly to produce. Again, that is inhibiting investment, it's inhibiting production. I mean, Petrotrin told us the other day that their cost of lifting is, I think, $47, that's what they see. So they're not making any money at all with oil at $47. So there will be marginal fields that have that kind of high cost. We need to settle these things because leaving the oil in the ground doesn't help anybody.
No, going back to LNG, if you don't mind. Yeah. Okay, good, yeah.
We done so that we're waiting until you tell us when?
The thing about it is, what was requested was a schedule going forward, and
Get an idea whether it will be in the next month, the next 2 months, the next 3 months, the next 6 months,
yeah, the next month, I will say the next month.
within the
Because
next month or so.
Within the next month, because what we intend to have is a series of stakeholder forums. They've been designed, as I said, around some clusters of stakeholders, inviting them in, having a full discussion, and getting that feedback and incorporating it into the policy development.
Sorry to belabor the LNG point, but I think it is extremely important. We in a revenue-strapped situation as we speak, as a government. And I get the impression from this discourse that whether either breach of contracts or not well-structured contracts, the state seems to be foregoing significant revenue from the LNG business and marketing. Is that a fair statement?
I would say yes, in broad terms.
No answer anymore. Right?
Okay.
So, and that is largely due because of, as I said, flawed contracts in inverted commas, the lack of monitoring capacity at the Ministry of Energy in particular as to where cargo's final destination occurs, and other certain shortcomings in the system. So it's something we have to put right, because to me, this is the largest stream of revenue that can now be captured by the state legitimately, even without the investment of a single cent. Okay, so it's not something to blink your eye at. With regards to marketing of LNG, I take Mrs. Pongwing's comments that when these contracts were put together, we were very inexperienced in the LNG business. As a matter of fact, the LNG business itself didn't know what its business was, because crude is marketed by indexed crudes, WTI, Brent, what have you. And the only difference in crude sales, because it's ubiquitous all over the world, is whether you're on a long-term contract or you're on the spot market. But crude sells basically at the same price based on the benchmark crude that you have. The gas business was not like that. Gas is not a transportable commodity except through pipelines, and that has its Henry Hub issues. And then when the LNG business came on stream, you was able to transport gas with regasification. So if you didn't have regasification, you couldn't buy LNG. And then the whole issue of destination came in. And so when these contracts were put in place, I understand there was a lot of ignorance on the market. The point I'm coming to is that there's a concept in law, and I am guided by my attorneys, called change circumstance. And I think the circumstance in the industry has changed so fundamentally that it could form the basis of a renegotiation. Am I right, yes, Mr. Small? Selma Solomon? And that is the principle which I would like the state to adopt, because this thing has changed fundamentally. Because you cannot tell me 3 years ago, let's say 5 years ago, all our LNG was going to Boston. 67% of Trinidad's LNG, we were the largest supplier, 75% to the US market. And that crashed because of certain circumstances. Now, all our LNG is going to Chile. And 5 years ago, it was going to Spain. So a contract could not have possibly covered all these scenarios. So again, just to summarize my thesis, I think if it is possible with a legal team, if we can invoke the concept in law called change circumstance, and if we can use that as a template to renegotiate some of these contracts or issues. It's a comment. I don't expect a response from it. No.
Mr. Lashley, I think we will have one more session with you. It will be in camera. where we can have more open discussions on LNG pricing and so on. Okay? But what I would, and we'll tell you when. What I would like now is for the members of the committee, do you have any other further questions for the Ministry of Energy? Sure. Mr. Dillon? Mr. Dillon?
So one question, Mr. Chairman, and it's different to what's on the question paper. It has to do with more the human resource component. We have seen an increase in terms of the international players in the gas industry. Is there a monitoring rule by the ministry with respect to the transfer of local content, the transfer of knowledge, and the encouragement of local, basically local content throughout? Is there a monitoring rule by the ministry? And how effective has that been?
Yeah, certainly, and I think the establishment of certain provisions for local content, some may argue, had the genesis in when the LNG projects were developed. There's a large element, and as you represented it for Point 14, I know you would have seen a lot of entrenched within some of the agreements, without getting into the specifics, were provisions for contributions and initiatives geared towards increasing and ensuring that local content and local inputs were addressed or maximized to a particular level. So there were some limits set in some of the contracts. In addition to that, contributions to some national efforts like the National Energy Skills Centers, etc., there were specific provisions for contributions over the life of the project to sustain or to support and finance the conduct of and the operations of some of these facilities. Now, that has been expanded even further under the PSCs and some other project agreements, where that focus on ensuring that as we develop the resource, there is that due attention being paid to the development of the human resource. And certainly that is something that we continue to monitor within the Ministry of Energy. In fact, we've recently resuscitated the Permanent Local Content Committee with a specific mandate to get into more detail and monitor more closely some of the operations and provisions and commitments of the companies going forward. So certainly that is I want to give you the assurance that that is front and center in terms of the ministry's agenda going forward, and in collaboration with some of the other stakeholders, we are moving forward full steam ahead with that.
Small comes in. In your responses, you told us that you have 144 vacancies. Could you give us some idea of what areas these are in? You said technical and administrative, but what do you mean by that?
I will let the DPS speak more specifically to that, but certainly it's a mix from inspectors, engineers, geoscientists as well as administrative.
Morning, Chair and members. These are positions and so on. It's a mix of both contract as well as established positions. Over the periods, over the years, we have in fact trying to see if we can get some of the established positions filled. We are re-looking at the structure. We have a proposal which would be sent to PMCD by next week. So there's a proposal on the table, and this is only looking at phase one of the structure. There's a broad framework that has been identified. Some of the issues for job descriptions and the core areas have been trashed out for certain divisions and sections within the ministries, and that will be forwarded for their comments, PMCD's comments, by next week.
All right, but what I'm getting at, all right, let me ask the question differently. For how long, for how many years have you had this level of vacancy, 144? Has it been going on for a very long time?
It has been with the ministry for a substantially long time. And it has been because of the restructuring process that has taken so long. Once a structure has been identified and there are changes in the administration and so on, each administration needs time to review. And rather than move forward with what was last proposed, there's always a continuous review that is taking place. We are hoping that this time that the review and the proposal can go forward straight through to implementation. This has happened because there has been a lack of implementation of the last structure.
And these are primarily contract positions, or?
No, it's a mix of established and contract positions.
But if it takes the Service Commission so long to fill vacancies, why are you focusing on establishment positions? Because you were told to do that?
No, I said it's a mix of established.
No. Listen,
Right.
I have in my own ministry, I'm looking at contract positions
Mhm.
in the government with a view to rationalizing them. And there's a view you should go for establishment positions rather than contract positions. So I know the general policy. But in a specialized ministry like the Ministry of Energy, if for 20 years you can't fill the establishment post, you know, in the army, they say if something is working, don't try to fix it. But if something is broken, you should try to fix it. I'm just wondering if your focus is on going the familiar route of trying to get the Service Commission to fill these posts, or you're going to focus on contract positions. It's just a question.
No, we have adopted a blend, in fact, because some of the contract positions are those positions, in fact, where there's no classification. Once you have positions that have been established and that have been properly classified, and so the policy has been to go with those positions. So you have geophysicists, you have geologists. Those positions have already been classified.
Right, and what I'm
So
picking up as well is that the salary is uncompetitive. They're not keeping people. So the point I'm making, if something hasn't worked for the last 20 years, why continue? That is, according to Einstein, that is the definition of insanity. Doing the same thing over and over and hoping for a different result.
So, Chairman, well, you went along the same road. That is the big issue for me. You have the ministry here before us today that is in charge of overseeing the energy sector, running at 65% of its manpower. That is simply not on. And I think that I always have a view, perhaps I have some little history on this matter, that the ministry also is able to recover its cost to the petroleum impost. So that for me, theoretically, there should be no holdback by the Minister of Finance and the sitting administration to make sure the Ministry of Energy is properly resourced. I believe that the challenges the country is facing now is because we have a dearth of people who want to work in the system. The system does not allow for flexibility, and it's certainly not the most attractive place. The important issue, Mr. Chairman, you hit it, is that these type of energy jobs have become more transient. People are not going to come to work in a place for 20 years. They want to come, they want to work for 5 or 10 years and move on to another place. And the system has to accommodate that. So the position you've taken, you've outlined about why we haven't been able to fill permanent positions, it's painfully obvious in my respectful view. And I believe, and I will support any initiative of this committee to give the guidance to support the ministry having the resources that it needs to do the job effectively. And I say that very clearly. The permanent secretary indicated that in the discussions with the companies on the issues we really raised here about the contracts, they have taken their position and they're holding. We need to be able to have the manpower and resources and the skills and capability to go in that room and hold our position also. It is a view I've exposed on more than one occasion and I continue to hold. Thank you, Mr. Chairman.
I'm speaking on behalf of the committee. We will give you any support you require. And I think you should start trying something new. And we will help you to see if you could get better terms and conditions and different ways of getting skilled professionals into the ministry, because you need it. Yeah.
I appreciate the support of the committee.
There was a time you all were paying a professional allowance. Is that still there, or has that been ceased?
It's still there for some categories of workers. There was an initiative actually to seek to improve it, which was not entertained at the time.
Show you that it will be entertained. Okay?
Chair, just
They recycle retirees, you know that? They come back as experts on better terms and conditions.
Just to clarify one of the issues, and I agree with Senator Small, and I think the opinion that our Minister Khan put out in terms of renegotiation of the contracts. Now, that is a process which I've seen it even when it happens between companies. It takes a while. So that is something which we can take and we will take. But certainly in the interim, we are also pursuing face-to-face discussions. I mean, those discussions have not borne any sustainable fruit. But certainly with respect to some of the contracts, as Mr. Jeremy alluded to, and Ms. Poywing, there have been changes. Some of them initiated by insistence by the ministry that the parties change some of the terms in order to make them more, in our view, fair in terms of the arrangements. And certainly on a face-to-face discussion, carrying on that dialogue in the interim, I think it's important.
Chairman, if you permit me, I think also the ministry needs to look at having the appropriate support. There's entities out there, and you can work out the confidentiality issues. If you approach the Oxford Institute of Energy Studies and say, listen, we'd like you to partner with the ministry to review some of these contracts and to help us to understand what is the best way to go about it. Or you approach the Jackson School of Geosciences, Bureau of Economic Geology, where you have people who are doing this, who are in the numbers and are able, and they would give their left arm to be able to look at real contracts and understand and give the government recommendations at a fraction of what it would cost for Wood Mackenzie or similar entities. We have to try to engage other entities to support the work that we're doing. And the ministry has these relationships already that I'm aware of, that you can try to find other parties to support what you're doing, not necessarily the guide, but to support the ministry and say, listen, have a clean eye, look at this first, and you can have a confidentiality arrangement that can work out and everybody signs the document and it's all wonderful. To support the ministry so that when you go in the room, you're powerful in the room. Right now, I think that what's happening in the room, that you go in the room and the rooms are staged properly and we're not as powerful as the others. And that is no reflection on us. It's just a capacity issue in my respectful view.
I'd like to wrap up now unless members have any other questions you want to ask. So I would just want to say, Mr. Lashley, and to your staff, it has been a pleasure. No, despite the questions we pose to you and the things we have said to you, speaking on behalf of the committee, I've really appreciated the way the ministry has made an effort to respond to our questions and give us the information we require. And we look forward to that in-camera session where we could see if we could get some more details on these LNG contracts. So thank you most sincerely.
Thank you, Chair.
Okay. I don't know when.